The footage from a beachgoer's iPhone would later be entered as Exhibit A in federal court. It was captured at 4:47 p.m. on a sun-drenched Saturday at Cocoa Beach, Florida. A black man in his mid-40s stood barefoot at the shoreline, board shorts dark with salt water, a faded gray t-shirt pulled across broad shoulders. He was alone, facing the Atlantic, letting the foam rush over his feet like a man who had earned every second of this quiet. Nothing about him suggested anything other than what he was, a tired professional finally exhaling on his one day off in 3 weeks. That's when agents Daniel J. Hernandez and Clint F. Dunaway stepped off the boardwalk and onto the sand. The moment their eyes landed on him, their posture shifted, their pace quickened. Hernandez reached for the badge clipped to his chest before they even closed half the distance. What neither agent understood in that moment, what nobody on that beach could have known, was that they had just walked up to the single most dangerous person in America to do what they were about to do. Not dangerous because of anything he'd done, but because of everything he knew. David Jenkins had spent 22 years as a civil rights attorney. He had argued Fourth Amendment violations before federal judges. He had deposed law enforcement officers just like Hernandez and Dunaway. He had won, repeatedly. And as those handcuffs clicked shut around his wrists in front of a crowd that was already reaching for their phones, something shifted behind his eyes. Not fear, not rage. Recognition. He knew exactly what was happening. He knew exactly what it was called. And he knew exactly what it was going to cost them. That one decision, made in under 60 seconds on a public beach, would end both agents' federal careers, trigger a Department of Homeland Security civil rights investigation, and produce a $12.8 million verdict that would be cited in ICE training reform briefings across the country. At least 7 phones were recording before the handcuffs came off. The agents had no idea. Before we go further, where are you watching from? Drop your city in the comments, because this story hits different depending on where you live. And if you're new here, hit subscribe right now, because what David Jenkins does next, from the moment those cuffs come off, is one of the most calculated and precise acts of legal warfare you will ever hear about. Cocoa Beach on a Saturday afternoon has its own rhythm. Families staking out territory with striped umbrellas. Kids shrieking at cold waves. The smell of sunscreen and fried food drifting off the boardwalk. It is the kind of American afternoon that asks nothing of anybody. Ordinary, loud, forgiving. David Jenkins had chosen this particular stretch of beach deliberately. Away from the rental chairs and the beach bars, closer to the quieter southern end where the sand was still firm and the crowd thinned out. He had a conference call Monday morning, a brief due Wednesday, and 3 clients whose cases were keeping him up at night. This afternoon was not a luxury. It was maintenance. 1 hour. Just the water and the wind and the rare, earned silence. He was standing barefoot at the shoreline, board shorts, faded gray t-shirt, watching a pelican work the surface of the water, when he felt it. That particular shift in the air that every black man in America learns to recognize before he can explain it. A change in the atmosphere. Something moving toward him with intention. Hernandez and Dunaway came off the boardwalk and crossed the open sand with the ease of men who had never once been told to stop. They were not running. They were not tense. That was the thing that struck the witnesses closest to the scene. How casual they were. How utterly routine this felt to them. Hernandez's badge was already out. Dunaway held a folded sheet of paper in his gloved hand, tapping it lightly against his thigh as he walked. They closed the distance. Hernandez spoke first. "Sir, we need to see your papers, identification, proof of status." The words hit the air like something dropped from a height. A woman 20 feet away stopped mid-sentence. A teenage boy froze with a football cocked behind his ear. The collective processing happened in real time across 24 faces. What did he just say? To him? Right here? And then, one by one, the phones came up. First 1, then 3, then 7. David Jenkins did not flinch. He did not step back. He turned from the water and looked at Hernandez with the measured stillness of a man who had been in rooms far more hostile than this beach, with people far more dangerous than these 2 agents. He had been black in America for 47 years. He had been a civil rights attorney for 22 of them. He had read the literature, filed the briefs, argued the cases, and sat with the clients who had lived through moments exactly like this one. He knew the choreography by heart. He knew his rights with the same precision a surgeon knows anatomy. What he had not known, until 60 seconds ago, was that he would one day be standing in the middle of it himself. He looked at Hernandez, then at Dunaway, then back at Hernandez. "On what legal basis?" David said, voice completely level. "Are you demanding my identification?" Hernandez didn't answer the question. He repeated the demand. And that moment of non-answer, of badge over law, of assumption over evidence, is where everything truly began. Not with the handcuffs, not with the footage. Right here, in this exchange on this sand, with 7 phones already recording and a pelican still working the water behind them, completely indifferent to the catastrophe quietly taking shape on the shore. David Jenkins gave them every off-ramp available. He stated his name clearly. He told them he was a licensed attorney, a United States citizen, born at Grady Memorial Hospital in Atlanta, Georgia, on March 9, 1977. He told them he was currently staying at a hotel 2 blocks from where they were standing, that he had ID in his room, and that he would be happy to provide contact information for the Florida Bar Association, which had his credentials on file. He said all of this calmly, without elevation, the way a man speaks when he has spent 2 decades understanding that tone is evidence. Hernandez and Dunaway did not take the off-ramp. This is the part that requires explanation, not excuse explanation, because understanding what happened next matters as much as the outcome. There is a documented psychology to this kind of escalation. Studies on law enforcement decision-making consistently show that once an officer has publicly committed to an action, the presence of an audience makes reversal feel catastrophically costly. To stop in that moment is to be wrong in front of witnesses. And there were witnesses everywhere now. Phones up, eyes wide, a loose semicircle forming at a respectful but recording distance. Dunaway moved. He stepped behind David with the mechanical efficiency of someone executing a practiced procedure, and the handcuffs came off his belt. David heard them before he felt them. That metallic sound, specific, unmistakable, and then the cold of the steel, and then the click. Twice. One wrist, then the other. The crowd reacted before David did. A woman audibly gasped. Someone said, "Oh my God," in a voice stripped of everything except shock. The teenager who had been holding the football set it down in the sand as if suddenly it was wrong to be holding something that casual. David Jenkins stood handcuffed on a public beach on a Saturday afternoon. A 47-year-old American citizen who had spent his entire professional life fighting for people in exactly this position, except he had always been the one standing at the counsel table, not the one in cuffs. He did not struggle. He did not raise his voice. He looked down at his wrists for a long moment, the Atlantic breaking behind him, and something settled across his face. Not defeat, not submission, something colder and more deliberate than either of those things. Those who were close enough to see his expression in the footage, and legal analysts would study that footage in exhaustive detail over the coming months, described it the same way independently in their witness statements. One beachgoer said he looked like a man who had just been handed everything he needed. A colleague who reviewed the footage later said it differently. He looked like a man who had just decided something. Both were right. The handcuffs clicking shut on David Jenkins' wrists was not the end of anything. It was the moment the real story started, the one that would unspool across depositions and courtrooms and federal oversight hearings for the next 3 years. In that single sound, Hernandez and Dunaway had converted a black man on a beach into a plaintiff with standing, a story with evidence, and a case with a paper trail that started the moment their own agency's camera system timestamped the footage at 4:47 p.m. They had handed him the first exhibit, and they had no idea. People who weren't there tend to imagine it wrong. They picture him shouting it, righteous and furious, face tight with anger, voice cracking under the weight of the injustice. That version is understandable. That version would have made sense. But that is not what happened, and the distinction matters enormously, legally, personally, and in terms of what those 4 words actually accomplished. David Jenkins looked at Daniel J. Hernandez and he said it quietly. "You picked the wrong guy. No performance. No tremor." The flat, certain delivery of a man making a factual observation in a professional context. The way a doctor states a diagnosis. The way an engineer identifies a structural failure. Not a threat, a calculation spoken aloud, for the record, into 7 active phone cameras and the salt air of Cocoa Beach. Hernandez blinked. That detail appears in 3 separate witness statements. He blinked, and for just a moment, something moved across his face that wasn't authority. Dunaway, standing slightly behind David, went very still. The crowd felt it before they understood it. The shift in weight. The sense that whatever power dynamic had operated on this beach for the last several minutes had just quietly and irrevocably reversed. This man in handcuffs, barefoot, gray t-shirt, wrists bound behind him, had somehow just become the most composed person on this beach. And the 2 federal agents flanking him had become something smaller, though neither of them knew yet exactly how much smaller. David wasn't finished. "I am a civil rights attorney," he said, still in that same register. "I have argued Fourth Amendment cases in federal court. I know what an unlawful detention looks like. I know what racial profiling looks like. I know exactly what is happening right now, and I know exactly what it is called under Title 42, Section 1983 of the United States Code." He paused. "Every phone on this beach is recording. I want you to understand what that means for you." One of the bystanders closest to the exchange, a retired schoolteacher from Orlando named Patricia Simmons, whose testimony would later be included in the civil filing, said in her statement that she started crying and didn't fully understand why until later. She said it was something about the contrast, the cuffs on his wrists and the absolute authority in his voice. The way he was simultaneously the most constrained and the most powerful person on that sand. Hernandez and Dunaway did not remove the handcuffs. Not yet. Whatever internal calculation was happening behind Hernandez's expression, it hadn't reached that conclusion. But something had shifted in how they were holding themselves. The casualness was gone. The routine operation energy had evaporated. They looked, for the first time, like men who were aware they were being watched. The Atlantic kept its own rhythm behind them. Indifferent. Continuous. The waves didn't care about any of this, which somehow made the moment feel larger. This small, furious, quiet confrontation between 3 men on an enormous beach, surrounded by dozens of witnesses, all of them understanding that they were watching something that would not end here. David Jenkins stood in the sun with his hands cuffed behind his back and waited. He had been doing this his entire career. He knew how to wait. He knew that patience, deployed correctly, was its own form of devastation. They released him 43 minutes later. No charges filed. No explanation offered. Dunaway removed the handcuffs with the mechanical efficiency he'd used to put them on, and then both agents walked back up the boardwalk without another word, as if the entire episode had been a minor administrative matter now concluded. As if a man's Saturday afternoon had not been taken apart in front of 60 witnesses and 7 phone cameras. David Jenkins stood on the sand and looked at his wrists. The marks were already fading. The crowd was not. Several people approached him. A man offered his card, said he'd seen everything, said he'd testify. Patricia Simmons, the retired schoolteacher, handed him a bottle of water with both hands, the way you'd hand something to someone who'd just survived something. A young woman, college-aged, said nothing, just showed him her phone screen so he could see the footage was already uploading. He thanked each of them. He was polite. He was composed. He walked back to his hotel room, sat on the edge of the bed with his shoes still sandy, and did not move for a long time. By 9 p.m., the footage had cleared 500,000 views across 3 platforms. By midnight, 1 million. By Sunday morning, David's phone had 47 missed calls. Colleagues, former clients, law school professors, 2 journalists from national outlets, a producer from a cable news network. He didn't answer any of them. He sat with the television off and the curtains open, looking at the water and let the calls go. What he was doing, though he wouldn't describe it this way until much later, was grieving. Not for himself specifically, but for the version of his Saturday afternoon that had existed before 4:47 p.m. For the hour of quiet he had negotiated with a brutal work schedule. For the pelican he had been watching. For the uncomplicated anonymity of just being a man at the beach. That version of the afternoon was gone permanently, and he allowed himself to feel the full weight of that before he allowed himself to feel anything else. Then he opened his laptop. The document he began drafting that night wasn't a complaint. Not yet. It was a timeline, precise, chronological, detailed. Every word spoken. Every observable action taken. The exact sequence of events from first contact to release, reconstructed from memory while the memory was still sharp. He noted the timestamps from his phone. He noted the names on the agents' badges. He noted the presence of witnesses and the direction their cameras had been facing. He had coached clients through this exact process hundreds of times. Preserve the record. Establish the timeline. Don't let the details blur. By 2 a.m., he had 4 pages. By 3 a.m., he had made a decision so clear and so settled that it required no internal debate whatsoever. He was going to sue. Not because he needed the money. Not because he was angry, though he was. Because somewhere on this beach today there was a man. Someone without his degree, his contacts, his 2 decades of federal courtroom experience, who had been through exactly this and had no idea what to do about it. Who had gone home and said nothing because saying something felt impossible. David Jenkins was going to make this impossible to ignore. There is a specific disorientation that comes with being a civil rights attorney who suddenly becomes a civil rights plaintiff. David Jenkins had spent 22 years on one side of that table. He knew every argument. He knew every delay tactic, every procedural motion, every way a government defense team would attempt to reframe a clear violation as a reasonable exercise of discretion. He knew all of it, which is exactly why he didn't represent himself. He assembled a team of 4 attorneys, 2 former DOJ litigators, a constitutional law specialist from the University of Florida, and his longtime colleague Renata Moore, who had spent 15 years specifically handling wrongful detention cases against federal agencies. He wanted people who could look at this case without the emotional proximity he carried. He wanted people who, when the government's lawyers tried a particular maneuver, would see it coming 3 moves ahead, the same way he always had from the other side. The FOIA requests went out within the first week. What came back over the following months was not surprising to David. But it was exactly what they needed. The records showed a pattern so consistent it read less like a series of individual decisions and more like an unwritten policy. Hernandez and Dunaway, across 31 documented stops over 18 months, had detained individuals of color at a rate of nearly 94%. Their incident reports were formulaic. Phrases like acting suspicious and inconsistent behavior appearing with copy-paste regularity, unsupported by any specific observable detail. Of those 31 stops, 6 had resulted in formal complaints. All 6 had been reviewed internally. None had resulted in disciplinary action. The complaints hadn't disappeared. They had been processed, evaluated, and filed away, which in some ways was worse. It meant the agency knew. It meant that what happened to David Jenkins on that Saturday afternoon was not a lapse in judgment by 2 rogue agents. It was the predictable output of a system that had reviewed this behavior and declined to correct it. The legal team added the agency itself as a defendant. David sat in on every strategy meeting but maintained a deliberate distance from the day-to-day tactical decisions. He trusted his team. More than that, he understood the psychological trap of being too close, the way personal injury could narrow vision at exactly the moment when wide vision was most necessary. He had seen plaintiffs damage their own cases by making it too much about themselves. The most powerful civil rights cases were never really about one person. They were about the pattern the one person proved. And the pattern here was irrefutable. By the time initial discovery closed, the legal team had 31 prior stops, 6 buried complaints, a federal camera system timestamp, 47 minutes of civilian phone footage, 12 witness statements, and a retired schoolteacher from Orlando named Patricia Simmons who, when asked to describe what she had observed, said simply, "They handcuffed a man for standing on a beach, and I knew, the moment I saw his face, that they had absolutely no idea who they had just done that to." The case was ready. The evidence was airtight. The only question now was how the government intended to defend it. They were about to find out. If you've made it this far, you already know this story is different. Hit that subscribe button and drop a comment below. Do you think the agents knew exactly what they were doing? Or did they genuinely believe they were in the right? I want to hear your take. Because what happens next in that deposition room? Nobody on the defense team saw it coming. The government's response arrived 48 days after the complaint was filed. It was, David noted without surprise, exactly what he would have written if he'd been on the other side. The stop was lawful. The agents had acted within their statutory authority under Section 287 of the Immigration and Nationality Act. The encounter was brief, professional, and resolved without incident. Mr. Jenkins had not been injured. He had been released. Any suggestion of racial motivation was speculative, inflammatory, and unsupported by the evidence. The agents were experienced federal officers with commendable service records who had made a reasonable judgment call in the execution of their duties. David read it twice. Then he set it down and told his team, "They're going to try to make this about me." He was right. Within weeks, the defense strategy revealed itself with the subtlety of a legal brief, which is to say, not subtle at all. They filed discovery requests targeting David's prior case history, his public statements on immigration enforcement, op-eds he had written, interviews he had given. They were building a portrait of an activist attorney with an agenda, a man predisposed to see racial profiling where none existed, someone who had perhaps recognized an opportunity on that beach and decided to manufacture a grievance. It was, David thought, almost elegant in its cynicism. He had used variations of this playbook himself, not against civil rights plaintiffs, but he had watched opposing counsel deploy it with devastating effectiveness against clients who didn't see it coming. The goal was not to win on the facts. The facts were a problem. The goal was to make the jury see David Jenkins not as a man who had been wronged but as a man with a motive. Turn the plaintiff into the story. Make his credibility the issue rather than the agent's conduct. The problem, as the defense team would slowly discover, was that David Jenkins had no credibility problem. His 22-year record was immaculate. His case outcomes were documented and public. His reputation in federal court was precisely what you didn't want facing you from the plaintiff's table. Every attempt to paint him as an opportunist ran directly into a wall of professional history that said otherwise. And then there was the footage. 47 minutes of it, from 7 angles in high definition, time-stamped and authenticated, showing exactly what had happened and contradicting the government's characterization at nearly every point. There was nothing speculative about it. It was simply what occurred. Hernandez and Dunaway, for their part, maintained that the stop had been triggered by a tip, a report of a suspicious individual in the area. When pressed in pre-deposition correspondence for documentation of this tip, the timestamp, the source, the record of receipt, the defense team asked for additional time to locate the relevant materials. They would spend the next 4 months looking for documentation that David's team suspected from very early on did not exist. Hernandez went first. He arrived in a suit, composed, prepared, a man who had clearly been extensively coached. His answers in the early hours of questioning were careful and consistent with the government's official narrative. The stop was routine. The tip was credible. His conduct throughout had been professional and measured. He expressed no regret, because in his account, there was nothing to regret. David sat at the table and did not ask a single question. That was Renata Moore's role today, and she had prepared for this deposition the way a surgeon prepares for a complex procedure, with absolute precision and no wasted movement. She started with the tip. "Agent Hernandez, can you describe the tip that initiated this stop?" He described it in general terms. A report of a suspicious male on the southern stretch of the beach. "When was this tip received?" He gave a time. 4:31 p.m. "And what was the source of this tip?" "A call to the agency's tip line." "Agent Hernandez, we have submitted a records request for all tip line logs from that date. There is no record of a call received at 4:31 p.m. or at any time in the 2 hours preceding the stop. Can you explain that?" The pause that followed lasted long enough that the court reporter looked up from her transcript. He couldn't explain it. He modified his account. Perhaps it wasn't the tip line. Perhaps it was a communication through a different channel. Perhaps the time was slightly different than he remembered. Renata gave him room. She let him modify. She let him construct the alternative account in detail on the record before she moved methodically through each element of it and demonstrated, document by document, that the alternative account was also unsupported by any retrievable evidence. Then she played the footage. Not all of it, a precise 90-second segment, timestamped 4:44 p.m., showing Hernandez and Dunaway in the parking lot, not responding to a tip, not receiving a communication, standing at the edge of the lot, scanning the beach. The footage showed the exact moment Hernandez's posture changed, the exact moment he pointed, the exact direction he was pointing, toward David Jenkins, who was simply standing there. "Is this you, Agent Hernandez?" "Yes." "And what had Mr. Jenkins done, in the 90 seconds visible in this footage, that prompted you to approach him?" The answer Hernandez gave, after another long pause, was the moment the case effectively ended. Not because of what he said, because of what he couldn't say. There was nothing in that footage. No suspicious behavior, no tip being received. Just a black man standing at the shoreline, and two agents deciding to walk toward him. Dunaway's deposition 2 weeks later produced nothing to repair the damage. By the time both depositions were complete, the government's legal team had a significant problem. Their entire procedural justification had been dismantled on the record, under oath, by the agents themselves. The trial date was set. The federal courthouse in Orlando was quieter than David had expected on the morning closing arguments concluded. He had sat through 8 days of testimony in that room, on the wrong side of the counsel table, which still felt strange after 22 years, and watched his team dismantle the defense with the patient, methodical precision he had spent his career perfecting from the other side. He had watched the jury watch the footage. He had watched their faces during Renata's closing, when she put the 90-second parking lot clip on the screen one final time and said nothing for a long moment before asking, "What did he do?" Now the jury was gone, and David was waiting. He had explained to people before, clients mostly, that waiting for a verdict was its own particular form of suffering, regardless of how strong your case was. Juries were human. Deliberations were opaque. You prepared the best case you could and then surrendered control entirely, which was, for attorneys, a specific and exquisite torture. David didn't experience it that way this time. He sat in the courthouse corridor with a cup of coffee going cold beside him and felt, more than anything else, calm. Not the forced calm of someone suppressing anxiety. The genuine calm of a man who had done the work, made the arguments, presented the evidence, and arrived at the point where the outcome would say something true about the world regardless of what it was. If the jury came back for the defense, that would say something. If they came back for him, that would say something else. He already knew what he believed the evidence said. The jury deliberated for 6 hours and 40 minutes. They filed back in at 4:22 p.m., a coincidence of timing that several observers noted, given that the incident itself had occurred at 4:47. David stood when the foreperson stood. The verdict for the plaintiff. Compensatory damages. Punitive damages. A federal finding of civil rights violations under Section 1983. And a total award of $12.8 million, the largest wrongful detention settlement in ICE enforcement history at the time of judgment. The room processed it in stages. David's legal team exhaled collectively. Renata Moore put her hand briefly on David's arm. He looked at the jury, 12 people who had watched 47 minutes of beach footage and 6 hours of testimony and arrived at the correct answer, and nodded once. Hernandez and Dunaway sat at the defense table and looked at the surface in front of them. The $12.8 million was not the point. Everyone in that room understood that. The point was the finding. The documented federal conclusion that what had happened on that beach was a civil rights violation. Not a misunderstanding, not a reasonable exercise of discretion, not a routine stop gone slightly sideways. A violation. On the record. Permanent. Both agents were placed on administrative leave within 72 hours of the verdict. Hernandez resigned 4 months later. Dunaway was terminated following a separate DHS internal review that examined their full history of stops, all 31 of them, in light of the trial's findings. The 6 buried complaints were reopened. 3 resulted in findings of misconduct. The Department of Homeland Security issued revised field guidance on immigration enforcement stops within 8 months, including new requirements for documented reasonable suspicion before any detention could be initiated. The guidance cited, in its preamble, the Jenkins case by name. David stood at a press conference 3 days after the verdict in a gray suit, no tie, looking out at a room full of cameras, and said what he had been thinking since the night he sat on the edge of a hotel bed with sandy shoes and an open laptop. "I want to be clear about something," he said. "I did not win this case because I was wronged. Thousands of people are wronged this way every year. I won this case because I had a law degree, 22 years of federal court experience, a network of colleagues who could build this case with me, and the resources to sustain a 3-year legal fight against a government agency." He paused. Most people don't have any of that. Most people go home, and nothing happens, and nobody hears about it. And the agents go back to the same beach the following Saturday. He let that land. This verdict matters. The precedent matters. The policy changes matter. But none of it answers the question that I cannot stop thinking about. Another pause. Longer this time. What happens to the ones who don't have what I have? The press conference ended. The cameras folded up. The room emptied. Cocoa Beach that evening was what it always was. Indifferent, continuous, the waves arriving and receding with no interest whatsoever in the legal history made in an Orlando courthouse earlier that week. The southern stretch of sand, quieter than the northern end, went through its Saturday evening the way it always did. Families packing up, the light going amber, then gold, then the particular deep orange of a Florida sunset that makes everything look briefly and improbably beautiful. No agents crossed the parking lot. No badges came out. The beach simply was what it was. A stretch of American shoreline where, on one unremarkable Saturday, a man had stood watching a pelican and 2 agents had made a decision they could not take back. The waves kept coming. The question David Jenkins had asked at that press conference hung in the air over all of it, unanswered the way important questions tend to. What happens to the ones who don't? If the story moved you, share it with someone who needs to hear it. And if you're new here, subscribe, because we cover stories exactly like this one. The ones that don't make the front page. The ones where ordinary people face extraordinary injustice, and what happens when the system finally has to answer for it. David Jenkins asked the right question. Make sure it doesn't get lost.